Hi, Jeff Rapkin for Sullivan Drafting Incorporated. Today I'm here to answer a question a lot of people have had. I know because at least 3 or 4 people per week ask me this question. I get telephone calls, people come into my office. All the time people ask me this question. I've seen this question on Facebook. I've seen this question all over the place. Schools don't know the answer. Even some attorneys don't know the answer to this question. Here it is. If a man and a woman who are not married have a child, who has custody? It's not who has the better residence. It's not who's the better parent. It's actually, per statute, mom has custody and dad has no rights whatsoever until he goes to court, files a proper petition, and establishes his rights through the courts, and a judge gives him rights. He has to go to court first to get his rights. And that is per statutes. I have put the statute in our website for you to see for yourself, but here it is. It's 744-301, subparens 1. Read the last sentence of the first paragraph. The mother of a child born out of wedlock is the natural guardian of the child and is entitled to primary residential care and custody of the child unless the court enters an order stating otherwise. Wow, that's it. There are several different ways to establish custody of a child. In a divorce case, in a Chapter 39 dependency case, all sorts of ways. In an injunction case. But when two people who are unmarried and there's no court case whatsoever, that mother has full custody, 100% custody. Father has no rights whatsoever. The mother of a child born out of wedlock, that is the natural guardian. Primary residential care and custody. Father has no rights. Dads, you've got to go to court. I have seen some pretty strange cases. Cases where mom has disappeared. Cases where dad has been raising the child for years. And all of a sudden mom pops up and says, I'm taking the child. What a disaster. Dads, you've got to go to court. You have to establish your parental rights. The courts have said so. Don't believe me? Take a look at the Florida Supreme Court form for the emergency pickup order. This is Supreme Court form 12.941D. And I've put that on the Sullivan website for you as well. 12.941D. Emergency verified motion for child pickup order. These are orders you get without even a hearing. A unwed mother can go to court and get a pickup order if a father, now this is without a court order, if a boyfriend or an ex-boyfriend says, I'm visiting with this child and I'm not going to give this child back, and there's no court orders whatsoever, a mother can go to court and get a court order to get this child back on the basis of this statute. Look at 4B. Custody or time sharing is established as an operation of law. 4B states, I am the birth mother of the minor child or children who was or were born out of wedlock. There's no final judgment or order awarding custody or time sharing with the following minor child or children, and then the names are listed. So if there's no order and boyfriend says, I'm a dad, I have just as much rights as you do, mom, I'm going to keep the child, guess what? No, you don't. No, you don't. And I have seen situations where dad will go to a school with a copy of the birth certificate. I've signed the birth certificate. I just have just as much rights as mom, and the schools will release the child. They don't know any better. Sorry, dads have no rights. The law is very, very clear on this. So, both of these documents are on the Sullivan Drafting Incorporated website. Look under the second tab under Guides. Next to this video, you can see for yourself. Dads, file your paternity case, file your custody case, establish your rights. You must do so in order to secure your rights to time sharing and custody. Thank you for watching.